Hey, and welcome back. Quick tidbit. In case you were still curious as to the significance of the state laws and the fact that your state laws are the medium and the vehicle to actually enforce the state constitution, because they were designed to be in harmony with it, and it can be used by you to hold people accountable. Here is a clause regarding civil rights within the 1866 version, which was the first one that was passed, that deals with the jurisdiction of the court and makes it very clear that your state laws are the medium to which the Constitution is meant to be enforced, that your state laws are the medium to which tabular demonstration of how much a felony, misdemeanor, or charges that violates the Constitution cost, that your state laws are the vehicle that you use to bring to life the Constitution beyond the things that it guarantees on its face, such as injunctive relief. It guarantees due process and all that stuff, but they still need vehicles because the circumstance can be broad or very specific. 1866 Civil Rights Act. Let's go to section 3. Towards the end of section 3. Section 3 deals with the jurisdiction of the court and how the court determines its jurisdiction. The District Court of the United States within their respective districts shall have exclusively of the courts of the several states cognizance of all crimes and offense committed against the previous provisions of this act, and also concurrently with the circuit courts of the United States of all causes, civil and criminal, affecting persons who are denied or cannot enforce in this court or judicial tribunals of the state or locality. So it's telling you they have subsequent jurisdictions, so long as any claim here is involved. If the other man or woman bring any other state claims, so long as they mention this law or the amendments of the civil right, the district court has jurisdiction. But here's the important part. The jurisdiction in civil and criminal matters hereby conferred on the district and circuit courts of the United States shall be exercised and enforced in conformity with the laws of the United States, so far as such law are suitable to carry the same into effect. But in all cases where such law are not adapted to the object or are deficient in the provisions necessary to furnish suitable remedy and punish offenses against law, the common law, as modified and changed by the Constitution, meaning in harmony with the Constitution, and statutes of the state, wherein the court having jurisdiction of the cause, civil or criminal, is held, so far as the same is not inconsistent with the Constitution and the laws of the United States, shall be extended to and govern said court in the trial and disposition of such cause, and if of a criminal nature, in the infliction of punishment of the part of the one found guilty. Now let me read that, because that was a long legalese. If you never really caught it, here it is. I'll read the specific part. The jurisdiction in civil and criminal matters hereby conferred to the district courts of the United States shall be exercised in conformity with the common law and statutes of the state, so far as it is not inconsistent with the Constitution, and shall be extended to and govern said court in the trial, and if of a criminal nature, in the infliction of punishment, those sentencing that we went over, and the party found guilty. It is letting you know that the jurisdiction, civil or criminal matter, of the United States District Court, who have the ability to enforce the civil right violations, is by way of the common law, so long as it's harmonious with the Constitution and the statutes of the state, so long as they are harmonious with the Constitution and the laws of the United States. And those same state statutes and common law extend to and govern the trials in the district court and disposition of the cause of action. And if it is criminally related, those same state statutes and common law govern the district court in the infliction and the punishment of the party found guilty. It is letting you know here that even if you do make a federal cause of action, or you have a federal question through the United States federal Constitution, your state common law and your state statutes are the medium to which even the district court is going to use to govern the trial and disposition of the cause. And if criminal in nature, the punishment is determined by the state common law and the compiled statute. It tells you right here. If you're in any doubt, the law tells it to you unequivocally right here. Chapter 31, Civil Rights Act of 1866. Every other civil rights that came after this is just an amendment to this, without this being repealed, redacted, or annulled. If you're ever in doubt that your state common law and your state statutes are the mediums to enforce all these substantive rights, there it is right there. Stop running away from your state laws. Use it. It's meant to be used by you.